All right. Welcome everybody to the Ad Hoc Commission on the Discipline System Closed Complaints Working Group. I will now call the roll. Shanae Buffington.
Here. Thank you.
Sarah Good.
Present.
Jerry Larkin.
Present.
Ed Lear.
Here.
Steve Moab.
Here.
Cynthia Nakau.
Here.
All right. We have a quorum. We have everyone. If anybody in the public who is participating in the attendees roster, if they would like to make a public comment, can they please raise their hand now? And I don't see any hands raised at this time. So we will move forward. One administrative thing. There we go. I will share my screen. Hopefully everyone can see my screen. And please feel free to interrupt me. It's not always easy for me to see everyone while I'm presenting. This is the Closed Complaints Working Group. The agenda for today, if you were on our call yesterday, this will look very familiar. We're going to review briefly what the issues around the closed complaints, and then identify the scope of the working group. What are we trying to accomplish? What changes or potential recommendations are we trying to come up with? And then giving what we want to accomplish, what research, information, data, or presentations would be useful to come up with that information. And so as a brief review, the Fairness Subcommittee discussed the topic of closed complaints, and they received a presentation from OCTC. We also had a presentation from Professor Robertson on the potential reforms that were discussed regarding closed complaints. And there were two main areas of closed complaints. The one talks about the closed complaints with no discipline and archiving those complaints or expunging those complaints. And then the task of this working group is talking about those closed complaints that are closed at intake where no action was taken and we do not notify the respondent of those closed complaints. And so that's really the focus of this working group. These are the potential reforms that Professor Robertson came up with, and they really talk about expunging of those closed complaints. His first recommended reform was expunging complaints closed without discipline after 5 years. The Board of Trustees chose not to adopt this. They adopted kind of a hybrid between potential reform 2.1 and 2.2. So the adoption was those closed complaints after 5 years are archived. And so they are not accessible to line staff unless they meet some criteria or they petition and it is deemed appropriate to give them access, but they are archived after 5 years. So the initial recommendation was expunge after 5 years and then archive all complaints closed without discipline. And the recommendations that were implemented was to archive after 5 years. And the Fairness Subcommittee decided to take a wait and see approach for these. And so since those recommendations were recently implemented, they decided not to come up with any additional recommendations regarding archiving. You can see potential reform here. 2.3 is develop a proactive non-disciplinary system to support attorneys at higher risk of future complaints. And this working group might weave into that because I think the idea of this working group is if there are a bunch of closed complaints that show a pattern or could help prevent an attorney getting future discipline. So if they were made aware of, if we could detect patterns or if we could look at things, that's kind of where this working group is looking, kind of focuses on those closed complaints at intake. This was part of the presentation that Melanie Lawrence provided at one of our subcommittee meetings. It just kind of gave you an idea of the scope of the closed complaints that we're talking about. And so you can see from 2017 to 2020, closed at intake, there were 51,000 original matters. So that's a huge amount of complaints that we get over that short time period. And these would all potentially, if the recommendation was to send out notifications to every attorney, you can see the workload that that would cause. These are some of the allegations that were in those complaints. And what Melanie made the case at the subcommittee meeting was that this would be a huge resource issue, even if we ultimately automated this type of work, that when we in the system we decided to close the complaint and auto-generated a letter and it was sent out to the attorney. The response to that letter, our call intake center would potentially have a significant uptake, because a lot of attorneys would want to have more information and would require, who is this, want to identify, the complaining witness, all the sorts of things that could be generated. There was also, from ADDC, there was also a concern that notifying the attorneys of these closed complaints could potentially cause issue when applications for employment or liability insurance or other things, that they would have to say yes, that they had complaints on them now, or I don't know that they would have to say yes, but that was an area where we weren't sure, and further study may need to be needed, but it could be detrimental to the attorney if they were notified of these closed complaints that had no issue. So that's a brief presentation. I'm going to stop sharing now, and hopefully I've been able to delineate between the archiving of the complaints and the actual closed complaints. And so I really want to discuss with the working group, is there information that the working group could meet? Is there data requests behind all of those closed complaints at intake? Maybe something around the number of complaints per attorney, other things, other data requests that the working group may think could be useful for us to research and bring back to the committee. And then there's also another issue that a lot of this has to do with the archiving of the complaints. And so those complaints can be looked upon at, even after 5 years if they're petitioned. And so they may be used and looked upon if there's some sort of pattern or something like that. And so I assume that this working group would probably benefit from a presentation from OCTC on those factors, on what makes those complaints eligible once they're archived to be looked at. And then what OCTC uses to look at once they do look at those complaints. How are they useful? What do they use them for? Are they looking for patterns? Are they looking for other things? Because maybe those same patterns that are looked at could be used as preventative. So as we are archiving these complaints, maybe we can reach out to the attorney and say, these are starting to look like a pattern. Maybe we send them a resource letter or do something like that. This working group could look at. So at this point, I've talked enough. I want to open it up to the working group to have a discussion on potential research needs or areas of focus or presentations that would be useful to the working group itself. Sarah, you have your hand raised.
I'd be interested to know why the archived complaints in this scenario are useful at all, and why just the prior complaints that resulted in discipline wouldn't be sufficient. So I would want that specific question, addressed by the relevant folks within the bar. What does this bring to the table? Because obviously closed complaints without investigation there's been no due process. They've been determined to not have sufficient evidence to proceed. So it feels unfair that they would be taken into account in the disciplinary process at all. And why wouldn't it be sufficient to rely on, those instances where there was some sort of discipline?
So I like Sarah's point, and sorry, did I just jump the line? I like Sarah's point, but and maybe everyone will be surprised to hear me say this a little bit as I'm the defense representative here, but I am a little curious about Justin's comment concerning patterns. And typically my knee jerk would be, no, Sarah's right. You can't use any information regarding closed complaints with respect to future conduct. But I liked Justin's comment about what if we were to take those patterns and proactively go out and educate and train those attorneys that have patterns. So for instance, an easy one. There are 5 complaints of failure to communicate against a particular potential respondent in a 6-month period. Well, there's something going on there. And so and proactively, before we get to the discipline point, even though they didn't rise to the level of actual misconduct, there are red flags there. How would we reach out? And well, let's start with that. And I don't even know if that's something that can be answered by one of the bar professionals. How would we reach out and what would we do? And the obvious answer on my little hypo would be, well, we would reach out and we'd say that there are complaints against you regarding your failure to communicate. We've noticed a pattern, and we want to work with you, not against you, in making sure that this doesn't rise to the level of misconduct. We have X and Y resources available. And again, I don't know what those are other than training, but I would like to explore that, and I just don't know how to.
Jerry, I see you have your hand raised.
Thank you. I want to add what Sarah and Ed said. This is fertile ground, I think, to be proactive. Some other jurisdictions do any number of things. Some actually, and this might be quaint, invite in people who are frequent flyers to have a chat, because Ed's right, it's a flag. And the goal is not to discipline, but and sometimes the in-person meeting has a better effect than a resource letter. So, and I know we talked about overdrafts, and you face a large quantity, a crushing quantity of grievances as an organization. So you have to be careful about where you devote resources. But I also see in situations where there's an overdraft report from a bank, one can get ahead of it and avoid the need for discipline. On the data point, though, just to supporting both Sarah and Ed, I think on the data point, I'd like to see of those disciplined in a given year, how many had a collection of a certain critical mass of these intake closures in the years prior. So I'm not a fan of keeping a record of these past, in our world, 3 years. We expunge and get rid of. But if you have them, it might inform what you do if you look back and say, of X percentage of the lawyers we disciplined for the same conduct that we had closed files much earlier. And while we could have done something differently, actually perhaps even averted the need to undertake a costly prosecution. And I'm sensitive to the volume of the work that you good folks do. So I wanted to support what Sarah said and Ed said, and maybe add some of my own voice to this.
Thank you, Jerry.
And Jerry, I did capture that data requested. We are, as one big project that Araya is wrapping up, is the categorization of our 500 plus allegations codes, so that we're able to really be able to look at complaints that were dismissed according to like different buckets of categories rather than the individual codes. So we'll be finishing that up this week. So we'll have that available to facilitate this analysis.
Shanae.
Hi. Okay, so just to piggyback off what Sarah and
Jerry said. So if the idea or one of the proposals is to inform attorneys via written notification, you know, about a certain number of complaints filed over a certain period of time, would that informational letter be subsequently used or against that attorney if, you know, that attorney faces discipline at a later point of time? Another question is, you know, if we don't, which I would think this would have to be in writing, but if we don't inform attorneys via writing, if we take Mr. Larkin's approach and invite attorneys that have a high number of complaints filed against them in a certain period of time, we do like a informational session. In that instance, again, would the attorney's participation, would it be mandatory? Would it be voluntary? And again, would participation in such groups or informational sessions about how to, I don't know, communicate more reasonably with your client, would that again be used against the attorney at a later point of time? And then for a data request, I think we probably covered this in our subcommittee meeting with fairness. But did we get a rundown of how much, because I know Melanie had presented that there would be a huge resource impact, you know, if we inform attorneys of closed complaints without discipline, but did we get like some actual numbers or anything like that of how it would impact the budget or state bar resources? I think we did, but I'm not for sure.
Yeah, I don't recall if we got into any numbers. I know that that was discussed, and there was concern about, you know, resources because we have finite resources, and that the amount of work product that this would generate. But I don't think we got into any details on that. I did note things that you said, Shanae. Sarah, you have your hand up.
I wonder if there's any data that can show the relationship between the number of archived complaints against future disciplinary actions that result in some action, whether it's private reproval or whatever, because that would then make more strongly the case that the number of closed complaints may be indicia of a pattern of practice or a flag with respect to that attorney, how that attorney practices law. Because one question I have is it may be a flag, but it may not be a flag of that. Maybe it's just that the attorney is practicing in the family law arena where these kinds of complaints come up more regularly, or in the criminal law arena. I know we had some discussions at one of our meetings about certain practice areas are particularly rife with emotion and complaints about services that, you know, may not be actually linked to any sort of deficiency on the part of the attorney practicing in that area, but just maybe a byproduct of the kind of legal practice that's involved. So it would be interesting to know, you know, that specific relationship, you know, X number of archived complaints over a certain year period, you know, was there any relationship to disciplinary actions subsequently? Maybe that requires too much work and isn't worth it. You know, I don't know, but wanted to just put that question out there. And then I'm interested in the practice area issue. Maybe somebody at the State Bar could speak to that a little bit more to see if that might be something that is coming into play here or not.
Okay. I know we definitely did present on that practice area issue, and what you were saying is there are higher risk areas to practice in, but we can bring that refresher back with at the next meeting as well.
Can you remind us, Justin or Lisa or Doug, when it was that attorneys began to be required to report their practice area? I think it's just January 2020. So I bring that up to say we have, I think, the information that we have in Odyssey, but I think going forward, we will have a much more clarity around practice area because of that requirement. And then in terms of the number of closed complaints that do ultimately result in discipline, I mean, I know we've looked at it the other way. In terms of our recidivism data, we've certainly looked at the number of attorneys who, or the percentage of attorneys who had some form of discipline who then receive a subsequent complaint. And that percentage is quite high. But I don't know how hard, Daggett, maybe you can answer that, how hard it would be to see the number of complaints that have been closed where that attorney ultimately at some point is disciplined. So I guess the question is, for an attorney who receives discipline, for how many of those attorneys have there been prior closed complaints? Or what percentage?
I certainly know the guy to ask, and I don't, it doesn't seem like it would be a super heavy lift. That's my impression of it, but I would certainly want to check with Ron. I think Ron would look at it, and I think that he's got the data organized in a manner that would allow him to look at that.
Can I sorry, just to clarify, so, but Sarah, you mentioned archived complaints, but we would look at all complaints. So some would be still available and some would be archived. And if we could like distinguish between those, that would be an added layer of that analysis. Thank you.
Yeah, it would be the closed complaints.
Closed complaints. And some
Yeah,
of those
closed complaints. Yeah, and one other question, are the closed complaints categorized by practice area?
No, they're not.
Okay.
No,
And I
these
think that I was going to say, I think that also points to one of these challenges with regard to practice type as an issue in terms of attorney misconduct, as opposed to the practice area. So it may be that an attorney lists as their practice area that they're a family law practitioner or a practitioner in criminal law, but the complaint may not be related to that particular area. So there's sort of a second level of coding that would need to be managed with regard to the complaints to track like what the complaint is specifically about in terms of practice.
Jerry, I see you have your hand raised.
I find this fascinating. I like the direction of the discussion. I think data can help us. In terms of a process, if that's the direction that the bar goes, of doing something more proactive with what otherwise would be closed complaints, I think one can rely upon the good judgment of the intake officers, probably with some criteria, to determine which of these massive complaints against some lawyers would actually bear fruit in offering some type of proactive intervention. I believe that one of your bar offices is creating a self-assessment tool. We have one, and we use it fairly aggressively, and it might just be that kind of intervention, and we give free CLE when someone takes it. We use we call it proactive management-based regulation. We use it where we think it makes sense. And the basis is that we think most lawyers are positioned to succeed, want to succeed, want to serve clients well, and they could benefit from some type of intervention. So I've given a couple of different examples. One is the chat, the other is a self-assessment. But if intake officers see there are features in those complaints against a given lawyer that would warrant something, I'd leave it to their discretion to do that. if they think this is just a, a really upset litigant in a criminal or divorce matter, they know enough to let that one go. Just my thoughts.
Thank you, Jerry.
So I like the discussion as well, Jerry. I think you're making some really interesting points, but I am concerned generally about how this could come back and bite respondents in the ass, which is to say that if we're at the discipline stage, and we'll go back to my easy example of the failures to communicate. So there are 5 failures to communicate that were closed out. There's a resource opportunity where either there's a chat or there is a training or some kind of MCLE that particular potential respondent goes through regarding communication. And let's just say it doesn't work. And then the respondent is prosecuted. And what I wouldn't want to see there is a listing of an aggravating factor, to wit, you went to this special training and you still didn't get it right. That would have a real chilling effect for any of my clients, where I would say, I don't want you to go to that, because it's going to come back and be used against you in a prosecution as an aggravating factor. So what I'd like to see there, if we continue on this path, is something like an ADP, where in ADP it's confidential. And so if the respondent that was notified or contacted by the bar about the 5 failures to communicate, if he or she then voluntarily either came in for a chat or went through some kind of training, the fact of that chat or the training would be in a confidential folder, where it then could not come back and be used as an aggravating factor in a prosecution.
Okay.
So
Go ahead, Jerry. Jerry, you're on mute.
thanks, Justin. I thought I hit the red button, but we have features like that, Ed, in several of our programs. We have one where we have intermediaries that are really experienced lawyers. A lot of them have LAP intervention training, where a lawyer goes off rails. They go and find that lawyer, and often it leads to no discipline, because whatever occurred, that lawyer is engaged, and the underlying matter might not have warranted necessarily a complaint. The rule pursuant to which that program is put in place says nothing discussed between the intermediary and the lawyer may be used. Now, the proactive management-based program is an online program. It's a little different, but there is, again, a provision that says none of the lawyer's answers in that self-assessment can be used in a disciplinary matter. I use those as 2 examples because I know we all get very creative when we need to. And Ed, I'm confident that if the bar sees value in this program, there's a way to achieve the results that you're looking to do. And I would applaud those and recommend those, because otherwise you won't get buy-in from lawyers who are capably represented by people like Ed.
Thank you, Jerry. Anyone else? So I think that this is a good set of data requests that we can kind of research and then get back to you. I also think that providing that presentation from OCTC's perspective on on the access to the archive complaints and what they use the archive complaints for will inform, because maybe there's a proactive approach we can take towards that. I don't have anything else. Are there any other questions or concerns that the working group has? I don't see any. At this time, I would like to ask for a volunteer who would like to chair this working group. If there's anyone that would like to volunteer to chair this working group, please raise your hand now, or you may you know, later on, like Sarah did yesterday, email me and say, you know what, I don't mind chairing that working group and I would like to chair that working group. So I'm always taking volunteers to chair these working groups. If anybody would like to, please let me know. And all the hands raised at once, that's a first. Oh no, none of them. Okay. Well, I appreciate everyone's time. And without anything further, we will be in touch to schedule another meeting once we identify the length of time it's going to take us to gather all these requests and set up the presentations. So thank you, everybody.
Thank you.
Thank you. Efficient meeting.
Thank you. Bye.
Bye-bye.